In reviewing the list of Judge Gorsuch's decisions on the 10th Circuit, two stand out as appearing to indicate his view of how a law should be interpreted and whether precedent should be overturned. And the first, which has been talked about before, but nonetheless very important, is a case called Trans Am Trucking. The driver, Alphonse Madden, was stranded in sub-zero temperatures for several hours with frozen brakes on the trailer and no heat in his cab. It was so cold, his torso was numb and he could not feel his feet. After waiting hours for assistance, Mr. Madden was instructed to drive the cab and the trailer together or not at all. When he could no longer stand the cold, he unhitched the trailer and drove to get help. Because of this, he was fired. The Department of Labor found he was illegally fired for refusing to operate the vehicle. In fact, the administrative law judge, the Administrative Review Board, and the majority of the 10th Circuit all agreed that he had been illegally fired for refusing to operate the vehicle as instructed by his employer. Judge Gorsuch disagreed. Instead, he argued in his dissent that the term operate should be interpreted by the Oxford Dictionary's definition, that operate should include only operating the cab of the truck, and Madden's employer could fire him with impunity. I find this striking. First, Judge Gorsuch's argument ignores the reality that Mr. Madden was given an impossible choice: risk your own life or the life of others on the road. Secondly, it ignores the fact that judges are not evaluating cases and interpreting law in a vacuum or a law school classroom, but rather cases are about real people and real life. In fact, the majority of his own court on the 10th noted that Judge Gorsuch's narrow interpretation of the word operate was based on one dictionary, while they had found a different dictionary definition that supported their reading of the statute. Simply put, which dictionary a judge happens to select should not and cannot determine whether a just outcome is achieved in a case. Judge Gorsuch's views were difficult to discern because he refused to answer many questions, even basic questions that have been answered by previous nominees. When I asked Judge Gorsuch about his work at the Department of Justice involving the Bush administration's defense of the use of torture, despite providing relevant documents, Judge Gorsuch said only that, quote, his memory is what it is, and it isn't great on this, end quote, and that the position he took on torture, quote, was the position that clients were telling him, end quote, to take. Not only did he not answer my question, he raised an additional concern. I strongly believe that when you work for the government, either as a lawyer or a policymaker, it's important to comment on the legality of the issue you advise or write. To say, I did what they wanted, is not enough, particularly if the legality is contradicted by both law and treaty. And as I've said, our job is to assess whether the nominee will protect the legal and constitutional rights of all Americans, and whether the nominee recognizes the humanity and justice required when evaluating the cases before him. Unfortunately, based on Judge Gorsuch's record at the Department of Justice, his tenure on the bench, his appearance before the Senate, and his written questions for the record, I cannot support this nomination.